大家早上好，欢迎来到翰林方允郭律师事务所 Halim Hong Gui 所举办的线上研讨会。今天将分享的主题为向违约承包商抵销合作价所需要的步骤与证据，以及委任第三方承包商。今天的线上研讨会将分为3个环节：第一，主讲人的分享；第二，问答环节；以及第3，评估环节。在此提醒各位，为了确保今天的线上研讨会能够顺畅进行，请允许我们将所有的参与者设为静音状态。若大家有任何疑问，请将问题输入在聊天室内，我们稍后将在问答环节中进行评论。在开始之前，请大家扫描荧幕上的2维码，以记录签到。现在，让我们介绍我们今天的主讲人 Miss Satshani。Satshani 是 Harold Lam Partnership 的律师，是一名合伙人。他主要从事的领域为建筑以及工程法，是各大雇主、承包商、外派承包商的代表律师，在法庭上代表他们解决了许多法律问题。请大家和我一起欢迎今天的主讲人 Miss Satshani。
Hello, good evening, everyone. Firstly, I would like to take this opportunity to thank Country Gardens for giving me this opportunity to speak in this wonderful webinar. Of course, thank you, audience, also taking your time off at this busy moment of yours to attend this talk. I'd also like to thank HHQ for organizing this webinar and making everything smooth sailing for all of us. So before I start my talk, please feel free to participate and ask questions. I have my colleague here, Felicia, who would be able to translate or answer your questions in Chinese if you require. So please let's have a two-way conversation here. And so the talk benefits every one of us. I have also my colleague here, Shahid, who would be helping us project the talk. Thank you. Next slide, please. Okay. Today, our talk is basically what are the rights of an employer, a right of an employer to set off any claims against the contractor. Okay. What is actually a set-off? A set-off is a remedy or a right that is available to the employer to deduct monies from a contractor. So example, if you're, sorry, there is some interruption. Just give us a moment, please, sorry. Yeah, okay. So coming back to a set-off, sorry, there was some interruption just now. A set-off is basically a right or a remedy that is available to an employer to deduct money due and owing to the contractor. Example, in an interim payment certificate. If there is payment due and owing to the contractor in the month of January, example, for 10,000 ringgit, and then the employer say, no, I would like to set off a sum of 2,000 ringgit because there's some default by the contractor. This is allowed under the contract, so long it falls under certain circumstances of which the employee is allowed to do. Next slide, please. There are 2 types of set-off. The first set-off is, of course, given to you or entitled by the employer pursuant to a contract. In a normal construction contract, we all know there are rights for an employer to set off. We would, of course, see these categories thereafter later on in our slides. The second category of set-off is post-termination. Post-termination, once the employer has terminated the contract, you don't have rights under the contract already to set off because the contract has terminated. This is where the law kicks in to say, okay, these are the rights that are available to the employer to set off any claims that is due and payable to the contractor. Next slide, please. Okay, now let's see some examples of a set-off during a contract duration. The very classic, but I need to put a caveat here that every contract has its own grounds for a set-off. But these are the general terms where an employer can set off against the contractor during a contract duration. Firstly, in circumstances where the contractor refuses to comply with an AI issued by the architect. This would be in circumstances where the architect says, okay, contractor, please carry out your work diligently and build this piling bricks, piling wall by next week. But your contractor refuses to do so. So what can a architect do, or what can the employer do? Because you have timeline to comply with. So the architect would issue an AI to say, okay, complete it within 7 days. If you don't complete it within the 7 days, I would then engage a third party and set off against payment that is due and owing to you. So long the architect can prove that the works were part of the contractor's original scope of works, the employer would be able to set off any payment that it has made to a third party. Second would be circumstances where there would be failure to pay any fees or charges in accordance with the contract. What does this mean? This means when a contractor was supposed to, example, pay the government, to get a government approval, you need to pay some fees or levies, but the contractor failed to do it. So what does the employer do to expedite the work? The employer said, okay, I will pay these monies on your behalf, contractor, but I would deduct this from any payment that is due and owing to you. Next. Okay. This is the most common circumstances that where an employer would love to set off payments against a contractor. This will be circumstances where a contractor did carry out the works according to the terms and conditions of the contract. But then it is not up to the standard required under the contract. So the architect comes and tells the contractor, please rectify your work. If not, we would engage a third party to carry out, to rectify and back charge it to you. The contractor refuses to rectify the work. So the architect or the employer has no choice but to appoint a third party to carry out remedial works, and this cost would be set off against any payment that is due and owing to the contractor. This will be similar to a compliance of any undertaking, wherein the contractor says, okay, I would carry out this rectification work within 7 days. But it's already 14 days and the contractor refuses to do so. So this would mean that his failure to comply with an undertaking. And undertaking means a promise that the contractor has told the employer that he would do it. In these circumstances, the employer can appoint a third party and set off any payment that is due and owing to the contractor. The next would be the general insurance claim, when in any construction contract, the contractor must take an insurance to protect his employers, his employees, his workers, and payment must be done promptly. But we all know sometimes contractors fail to do so. In these circumstances, the employer would take the effort to make payment for the insurance and so forth. And these payments would amount to a set-off against any payment that is due and owing to the contractor. Okay. Of course, we have seen the general circumstances of what is a set-off, in what circumstances can we actually set off payment. But what is a procedure like in a set-off? Of course, the procedure differs depending on the form of contract. Every contract has its own procedure. But the general term or the common procedure in a construction contract, first, you must always put yourself as the contractor and see, okay, how would if you want to claim monies against me, if you want to deduct, if an employer wants to deduct money against a contractor, you must always think, how would we prevent the contractor from rebutting this claim? Because contractor will come and always say, no, you are not entitled to deduct this money, you're not entitled to deduct this money. So what can we do? So we must always put ourselves in the contractor's shoes and think, okay, if the employer wants to deduct the money, what would the contractor say or do? So when we know what the contractor is going to say or do, we would then take steps to prevent this from happening. A classic example a first step in a set-off is this. You need to give written notice from the contract administrator. That means the architect must give a written notice to the contractor to carry out any works or specifying the works that it must carry out. So example, there is a defective work and you are not happy with the contractor, but you need to give the contractor one chance to carry out this work. So the architect must issue an AI saying, okay, please rectify these works within 7 days, failing which I would appoint a third party. This written notice is crucial for any claim because the contractor would always rebut and say, I don't know there was this work. If you given me an opportunity, I would have rectified this work. But so therefore, this written notice is very, very important for the contract administrator to give the contractor. Next. Secondly, only if the contractor fails to carry out the works, the contract administrators, who usually the architect, would then give a written notice saying to the contractor, I'm going to appoint a third party and I'm going to set off this cost against any payment that is due and owing to you. We must remember, we must always give a rough estimation of the cost that we would like to set off against the contractor. It is best within the 7 days duration, we get quotation from other contractors who are able to carry out these works. So when we give this second step of the notice to say we are going to set off this claim against the contractor, we have a rough estimation of how much we are going to set off against the contractor. And the contractor is fully aware of this cost. Because in legal cases, when it comes to court, the contractor would always say this, I did not receive receive notice. I was not aware of this cost. How can you set off against the monies due and owing to me? And the architect must also be very, very clear of what is the scope of works that the third party would be carrying out and the full details of these works. It is very, very important for these steps to be followed because this is what the court is looking for. Notice, details, cost. If you have given all these three things to the contractor, I don't see why an employer cannot set off a cost against the contractor. Okay, now comes the next step. Okay, you have given this, you have issued an AI to ask the contractor to carry out these works. And then he did not carry out the works. And then you give him this cost, this notice, everything you have given him. Finally, he comes and disputes it and says, I dispute this claim because I have carried out these works up to the level required under the contract. And your AI is something not within my original scope of work. So this then comes to what then happens, because you have had one hand the contractor disputing the set-off, you have one hand the architect who is trying to push us to do the work because the employer would want to meet the timeline and the deadlines. So what then do we do? Under each contract, there is specific procedures to actually proceed when a set-off is disputed. So please look into each contract. I have taken an example from the PAM contract because generally the PAM contract sets up a very general ground on how to go about a set-off that is disputed. Example, in a PAM contract, upon receiving the notice to set off from the contract, the contractor must respond within 21 days to agree or disagree. If the contractor disagrees, the dispute would be first referred to adjudication, and thereafter the parties can refer the same to arbitration. This is what is provided under PAM. But of course, it depends on individual contract. Every contract has a separate procedure. But the most important thing in a common, in the most common procedure is notice. You are giving notice, written notice to say that please carry out the works. If they don't carry out, a written notice to suggest the cause, and then a precise detail of what are the scope of works that you would want them to carry it out. You want the third party to carry out, sorry. Next, once these procedures are set up, what are the evidence that you need to collect for a set off? Of course, like what I have suggested previously, a written notice stipulating the default and the duration to rectify the defects. You need to give this written notice. Tell them what the contractor has not done. How long are you giving them a duration to rectify these defects? Of course, here, if someone asks me, how long should I give them to rectify these defects? Honestly, it then comes down to reasonableness. If you have a small defective work or small item to be carried out, of course, you give them 2 to 3 days. If it's a huge item, then you, of course, give them 7 to 14 days to rectify it. So it honestly depends on the duration, but the approach to apply is reasonableness. What is reasonable for a common man or a lay person to carry out those works? Secondly is a complete list of defect and associated costs, as explained. You need to list down what are the defective works. What do you want the contractor to carry out? And what are the associated costs if they don't carry out? So you get an associated cost from a third party, and then you submit it to the contractor to say, okay, you don't want to carry out this. These are the costs that you would incur, and I would set off against any payment that is due and owing to you. What is important to note here is, other than what I've told, the written notice, a precise list of defects and costs, the court would also see, have you mitigated the loss? What do you mean by mitigation? Mitigation means, have you tried to reduce this cost in any way? So example, you are appointing a third party, and there is example, 5 people who have quoted you to carry out these works. So you said, oh, I want the highest amount because I can back charge it or set off against a contractor. The court will say, no, you need to take something that is reasonable and appoint that person that is reasonable. You cannot take someone who's the most expensive contractor and back charge it to the contractor. You need to take a contractor or a third party that is reasonable. That's why you show court, the court or any forum where this dispute goes. Example, that you say, I have got several quotations. I've got example 5 quotations, and I've taken the most reasonable one. Example, you take I wouldn't say the cheapest or the most expensive, maybe the middle. See, I have mitigated my cost. I have inquired from other third parties of this cost, and these are the steps that I've mitigated. So court would always like to know, what steps did you take to mitigate your loss? Next slide. Okay, now we have looked into a set-off where there are express provision or terms in the construction contract. Generally, a set-off in a construction contract which involves express terms in the contract is quite clear-cut. You have the clauses where it sets up when you can set off. You have the clauses which will set what is a procedure and the evidence. So those are clear-cut cases, which generally would not be an issue. The question then comes up is, what can I do? What can I do in a set-off when there is no express clauses? This happens when a contract is terminated, is where this entire issue happens. As what can I set off? How do I set off? And the procedure, because you don't have a governing proceedings, governing procedure, because you don't have a contract. Before we go into that, you would usually try to set off when a contract is terminated. What are the common circumstances when a contract is terminated? A contract when it's terminated, when the contractor fails to commence work, when the contractor suspends work on site, when the contractor fails to proceed with the works regularly and diligently, when the contractor abandons the work, or the contractor's failure and refusal to comply with the AIs. In these circumstances, the employer is allowed or entitled under the contract to terminate it. Say, I'm going to terminate this contract, you're not doing it. But of course, when a contract is terminated, the employer would face several losses. So what are these losses and who bear the cost of these losses? Is it going to be the employer? Is it going to be the contractor? So we will move on to see who would face these losses. And what are the head of claims that you can claim against the contractor? Of course, you have several heads of claim that you can settle when a contract is terminated against the contractor. The general category is, of course, liquidated ascertained damages. Secondly, with the cost of completion by third party. Third would be the head office cost. And fourthly would be the loss of income/profit. We would go into first the category of liquidated ascertained damages, which is LAD. What is an LAD? An LAD is a clause set out a predetermined estimate of any losses which the employer is likely to incur if a project is delayed. So an LAD usually kicks in. For people who don't understand LAD is a clause which is always in a construction contract. I have to be honest, I've never encountered a construction contract which does not contain an LAD clause. So an LAD clause, the contractor and the employer would have determined, okay, if I delay my works beyond the original completion date, I will pay the employer usually, I've not seen anything less than 10,000, depending on the value of the project or the contract. So example, the contract says LAD sum of 10,000 per day. So if the contractor fails to meet the original completion date, the employer is entitled to charge the sum of 10,000 per day. So then what happens? A lot of questions would then become, the issue would be then said that, oh, the LAD sum is too much. It's 10,000 per day. Until when would this LAD sum run? And so forth. So there has been a change in the law in respect of this LAD, which we would go further to it. But generally, LAD is a clause that has been agreed between the parties when parties have signed the contract. It is a sum that the contractor would have in mind to say, the employer would have in mind to say, okay, if an employer has breached a contract or the contract is terminated, I would face RM 10,000 losses of RM 10,000 per day. So this figure is not a figure that is out of the air. It's a figure that the employer would have calculated and estimated his losses. Okay, so before I go to the law of LAD, it is utmost important and crucial for us to understand that for us to claim, or for the employer to claim LAD against a contractor, it is very, very important for certain prerequisites to be complied with. What are the prerequisites? The prerequisite or the procedure to impose an LAD is the contract administrator, the architect, must issue the CNC. A CNC is Certificate of Non-Completion. Why is it important for the CNC to be issued? First, the CNC would actually warn the contractor that I am going to impose this LAD because you have failed to comply with the original contract duration. And this would also notify the employer to say, okay, the contractor has not completed the works within the original contract duration, and you are entitled for these damages. So this, in law, this is compulsory. So if example, the architect said, oh no, I forgot to issue the CNC, and now after 1 year, he wants to impose LAD, and the contract is terminated. I'm so sorry, the employer would not be able to impose this LAD because this CNC is mandatory. The issuance of CNC is mandatory. So please take note that every time the contractor fails to comply with the original contract duration, fail to carry out the works in accordance with the original contract duration, this CNC must be issued. There is no specific form for the CNC to be issued, so long the CNC contains the fact that I'm going to impose LAD against you, and the employer is being informed of his rights to damages. That is sufficient. But usually the architect would state, okay, in accordance to clause so and so, you're supposed to complete the works within certain date. You have not completed the work within this date, and the LAD would be imposed from the next date of the original completion of work. Example, if the work was supposed to be completed on 1st January 2021, but he failed to do so, the CNC would take effect from 2nd January 2021. So your 10,000 would start running from 2nd January 2021. So please take note that the issuance of CNC is mandatory. Next slide, please. Okay, what are the evidence for you to claim an LAD? This evidence, this is where there is a change. There is a change in our Malaysian law. Previously, in our federal court of Selvakumar and Johor Coastal, the federal court, which is our apex court, have said that although there is an LAD clause agreed between the parties, the employer must still prove his losses that he has suffered. He must still go back and find his accounting statement, his overhead costs, all the costs that he has incurred to prove that he's entitled for this money. So it seemed a bit unfair to the employer, because the employers were taking the argument to say that it was an agreed clause between the parties that I would charge 10,000 if the works are delayed. But why should I come to court and now prove my claim when parties have agreed to this 10,000? But this was the position by the federal court, and it was for some time. That the contractors were benefiting from this clause. Then came the recent Malaysian court. In 2019, a recent the federal court in our case of Cubic Electronical Sdn Bhd changed this position. In this case, in this federal court case, the court came and said, okay, we have looked into the circumstances of the construction cases, and we take the position that the employer is no longer obliged or responsible to prove its losses. Because the federal court took this position, you have entered a contract agreeing to pay 10,000. Why should now the employer have the burden to prove this 10,000 when the contractor has agreed to it? So in Cubic Electronic, the position on LAD has been reversed. All now the employer needs to do is he needs to adduce evidence to suggest that the contractor has breached the agreement. When is a contractor breached the agreement? Clear cut. The contractor has breached the agreement when he did not complete the works within the original contract duration. So the minute the contractor has failed to carry out the works within the original contract duration, there is already evidence of breach of the contract. Secondly, he needs to contain an LAD clause to say that upon this breach, I'm entitled to impose this 10,000. So long these two conditions are complied with, it is now decided that the employer would be able to claim the monies that it has agreed to impose between the contractor and the employer. Then would be the evidence, or what would be now, the question would be, till when can I impose the LAD? Until when would this LAD run? Because we must always remember that an LAD clause is contained in the contract between the contractor and the employer, because you don't have a LAD clause elsewhere. So once the contract is terminated, technically the LAD clause also gets terminated. So then what would the employer be left with? Because I have already terminated the contract to appoint a third party, and who is going to bear these losses? This is where the UK, this is where the latest decision in 2021, a UK decision, Triple Point Technology would say the court held that the LAD clause would be applicable from the date of the original completion up to the date of termination. So example, like how just now we have given, you are supposed to, we are imposing LAD from 2nd of January 2021. So we give the contractor chance to carry out the work. Okay, we say, we're going to impose you a LAD, but we allow you to carry out your work. Then comes May, and you said, oh no, these works are not proceeding as what we have planned. We need to terminate the contract. So you terminate the contract in May. So the court has taken the position that from 2nd of January 2021 up to May, the employer would be able to impose LAD. The question then arises, what then happens for the losses that I'm going to incur post-termination? Because I can't claim, because the court said you can't then impose LAD post-termination because the contract is terminated. The LAD clause no longer survives. So then what happens? The court in Triple Point went further to say that went further to suggest that the employer would be able to claim all these losses that he has suffered post-termination under general damages in law. What are general damages in law? General damages in law are all the losses that the employer is able to prove and have supporting documents which are reasonable to be imposed against the contractor. Okay. The most common cause would be the cause of completion by a third party. And this is always an issue in court. I've also faced a recent case in court when coming to the cause of completion by third party. And these are the few things that I've also learned where the courts are very picky on imposing the cause of a third party. Firstly, there are certain, in my view, these are the steps that the employer ought to take when a contract is terminated. Upon termination of the contract, the employer would engage a third party to replace the contractor to complete the balance work. That is normal. The second thing would be the cost incurred. How are we going to measure the cost? These are just general terms. Later I'll explain in detail. The term would be the cost. How are we going to measure this cost? Generally, as all lawyers, what we do, we just take, okay, the original contract is example 100,000. As of May 2021, the contractor has completed 50,000. So the balance that is due and payable is 50,000. Then you appoint a third party contractor. The third party will come and say, oh no, I need to carry out these works. It's difficult. I need to take over. So I'm going to charge you 80,000. So generally, the actual cost that the employer has incurred is 30,000. But what the court has now decided and said, you cannot just come and tell me that, oh, 80 minus 50, 30,000 are the losses you have suffered. You need to prove these losses to me. I cannot just give you 30,000 because the contract says so. So the next step, when we're going to look into the slides, we would see what are the evidence that we require for us to claim this 30,000. And of course, we need to mitigate the losses again. The employer must get several quotations from other third parties to mitigate the losses. You cannot just take the most expensive third party contractor. You need to take someone that is reasonable to carry out these works. Okay, what is the procedure to appoint a third party? Okay, this is where the steps comes in. And I think this first step is always missed out in any post-termination, which is what the court said. But the case is not reported yet because it was a proceeding that we just got our decision. So, and I can't mention the party's name because we are appealing. But this is the first step. Firstly, it is best to carry out a joint measurement with the contractor to value the works carried out on site. Why is this important? This is very, very important because especially in a remeasured contract, because there would always be dispute as to the value of works carried out when you want to impose these third-party claims to the contractor. So the contractor would say, no, I've carried out my works up to 50,000, but you are saying, no, your work when I remeasured is only 45,000. So there's always an issue when it comes to this post measurement after post termination. So first, before a third party carries out the works on site, it is best for a joint measurement to be carried out with the contractor as well as the employer, because this would then set and say cast in and for both parties to agree, okay, till the date of termination, this is the value of work carried out on site, especially in a remeasured contract. Thereafter, what should we do? Thereafter, after measuring, after we have carried out this joint measurement, we would then give a written notice. This is once again very important. If you want to claim any money from the contractor, the employer must provide a written notice to suggest, I am going to set a back charge these monies to you. Give a written notice to the contractor notifying the cost of the third party. So you are going to, and you need to be fair to the contractor. What you need to do, you take all these 5 quotations and say, okay, these are the 5 quotations I have. I've chosen so-and-so contractor because he's able to carry out the works within the shortest duration, example. So you need to justify, you don't need to go in depth to justify, but it's best to explain why you have chosen this specific contractor, because this would then clearly suggest that you're carrying out works in good faith and you've mitigated your losses. So this is once again, like what I have explained, you need to mitigate your losses. So you, like how you have given your quotations to the third party. So I will not repeat that again. Once again, upon the confirmation of the new contractor, you give you give your contractor a notice to suggest the cost, and you will once again remind them that this cost will be back charged against them. Then, next slide, please. Then comes, okay, now you have given notice, you have notified you have carried out a joint measurement, you have given them notice you're going to back charge, and then you're back charging all these claims against a contractor because you say that due to your default, I'm incurring this cost. But what is actually the court looking at? What evidence do you need to have as an employee to back charge this? In this case of Isotech Electrical Sdn Berhad, the court decided on evidence which has to be adduced to establish by the employer's entitlement to appoint a third party. First, you need to show that the court said you want to claim this money, you need to show there was uncompleted works by the defaulting contractor. So this is clear cut. As just now you would have carried out the joint measurement, you can prove this. You can show, okay, I carried out a joint measurement, they did not complete the work up to 100%. Second, you need to show that the works carried out by third-party contractor is exactly the same scope of work left by the defaulting contractor. And this is very, very important because you cannot now, when you're appointing a third-party contractor, add on additional works to the third-party contractor and back charge it to the defaulting contractor. That's not fair on the defaulting contractor. Example, you're supposed to build a house. The defaulting contractor is supposed to build a house. And suddenly when you're appointing this new third-party contractor, you add a swimming pool to it and you want to back charge it to the defaulting contractor. That is not fair. So the court would always want to see that in your letter of award, you must ensure your BQ items and so forth are all similar with the original scope of work. You need to show that, okay, originally the defaulting contractor is supposed to carry out A work. Similarly, now in the new third-party contractor, he's also carrying out this similar work. It's just that the cost has increased. So this is where it is very important in the letter of award. It is best to stipulate the scope of the balance work that is to be carried out by the third-party contractor. Next. Okay, before I go to the next claim, I would also like to emphasize in this when it comes to appointment of third party. In appointing a third party, the court has expressly said in this ISO case that merely adducing award is insufficient. You cannot just come and tell court, okay, court, I have appointed third party contractor and his letter of award is 80,000. The original contract where the balance sum that is left with is 50,000. So losses is 30,000. The court said that is insufficient. The court has went on to say, merely adducing a letter of award can be done by anybody. I can just produce a letter of award today, sign it, and adduce it in court tomorrow. So the court said this is not sufficient. When you want to claim any losses against a defaulting party, especially when you're appointing third party, the cost is huge. The court said you need to have the letter of award, of course. You need to also prove that these are the similar scope of works, and you need to prove payment. You need to prove there is payment done to this new contractor and how much payment has been done. So if you have paid this new contractor 80,000, you need to prove this payment has been done for 80,000. So you need to always prove it. So these are very, very important. Just to recap on the appointment of third party, carry out a joint measurement first once a contract is terminated. Provide them written notice to say that you are going to back charge these losses that you have suffered, especially the appointment of third party. Once you have appointed the third party, please submit via written letter, submitting the quotations that you have received to notify them that these are the amount that you will back charge. And fourthly, when you are claiming these monies, it's best for you to actually provide the payment, the receipts of payment that you have made to these third parties. Now moving on from third parties, what other claims can you get after you have appointed third party? Okay, that's a separate head of claim. You're going to claim against the third party, the defaulting contractor. So what are the other head of claims that you can claim against the defaulting contractor? Would be a head office cost. What is a head office cost? A head office cost would be all other costs that you have suffered due to this prolonged contract duration. So example, you're supposed to leave site on 1st of January 2021, but now your contract is prolonged and you need to stay on longer on those premises. So what can an employer? An employer would generally suffer cost of head office staff, consultant and associated works, electricity bill, insurance claim, rental of any premises which the employer is paying on a monthly basis. What is the procedure now to claim a head office cost against defaulting contractor? First, once again, it's the same step. You need to notify the contractor via written letter that this would be claimable as a loss and expense claim. A loss and expense claim, you need to actually tell them, I'm incurring these losses because of your default, wherein I need to stay longer on site. Whenever we are going to claim any monies against a defaulting contractor, we need to notify and explain why are we claiming these monies against them. Upon completion of the works, the employer would submit the details and particulars of these losses suffered with the summary of payment. It is very, very important to remember we need to submit the summary of payment. This summary of payment must specify that these people in the office are for that specific project. You cannot take a head office claim from your main office and claim against this defaulting contractor, no, because it has happened before. So what you must do, you must always say, okay, I think when you're already aware that this contract is terminated and you're going to claim this head office cost against the contractor, then what you must do, tell your accounting team, please separate their payment for their salary sheet for this part and mention the project name at the top. So it's easier when you go to court to justify this cost against the defaulting contractor. It is best to mention the project in the title of their salary slip and so forth. Because premises is easy, you have rental agreement, so that will be easy. The concern would usually be the salary slip, because there will be always argument by the defaulting contractor to say, no, this worker was perhaps working for a different project and they're claiming it against me. So it is best to mention the project's title on that salary slip. This is something important to note to make your life easier to claim these monies against a defaulting contractor. Similarly, this is what I've explained. You need to collate all your evidence and information that you have paid, your salary slip, your insurance, all these you must prove that is specifically for this project. So long you can prove specifically is for this project and this costs were incurred due to the prolonged duration, generally the court would award this cost to the employer. Okay. Loss of income and profit. So what is loss? Loss of income and profit, to be honest, it is a very sticky area. It is not something that it is easily claimable. It is something you can claim so long you can prove it. But loss of income is something difficult to prove unless you have an expert who comes in. And usually for loss of income and profit, we have experts coming in to justify the computation of these losses. So it depends on each individual project. Example, in certain project, of course, it will be easier to ascertain the losses. In certain project, it would be difficult to ascertain the losses. If you are building a hotel and your hotel is delayed, example, the hotel, you're supposed to charge 300 per room, and you take a general amount, a general calculation of renting out half the rooms, you can calculate generally your loss of profit when it completes within 3 years. But if you have buildings that have been built up or lots that has been built, it would be a bit difficult to ascertain your loss of income or profit. It's difficult for us as lay people to calculate, but of course you have experts in the construction industry who we all engage. They are able to have a formula to calculate this loss of income or profit. Next slide. Okay. Now we'll move on to the next header of claim, retention monies. Okay, what are retention monies? Retention monies, there's also some changes in the legal position in respect of this. Retention monies are amount withheld by the employer as security for the performance by the contractor in respect of the quality of work. It's very important to remember retention monies is for the quality of work. So every month, generally retention monies are maximum 10% of your interim payment certificate up to 5% of your entire subcontract sum. So these monies would be deducted. Example, you deduct in every interim certificate, you deduct example 1,000 ringgit, 1,000 ringgit, 1,000 ringgit. Generally, at the end of the contract, if your contract is not terminated, you would release the first moiety. It's called first moiety, is half of the money once the contract is completed. And the second half would be released when the CMGD is issued. These are monies that usually the employer would retain for the quality of work. So if the quality of the defaulting contractor's work is defective or it requires rectification work, the employer would be entitled to utilize this money. But it's very important to remember retention money ties back with the quality of work. It's only for defective works or which requires rectification. You cannot take these retention monies and set off, for example, insurance claim or charges that you have paid on behalf of for the defaulting contractor. No, these retention monies can only be held, can only be utilized by the employer when it comes to the quality of the contractor's defaulting contractor's work. There has been, I've not cited the legal case here, but just for parties to know, previously under our Court of Appeal case of Kimonda, retention monies were held on trust by the employer. What do you mean held on trust? That means these monies must be returned to the contractor if all the works were done properly, correctly, and up to the standard of the contract. The contractor cannot retain this money because the court were of the view that the employer is holding these monies on trust. What happens then when the issue then crops up when the employer has been terminated? When the employer has been wound up, When the employer has been wound up, these monies will then go to the liquidator. So the contractors will come to court and say, these monies were held for me on trust by the employer. I need to get these monies back. You can't keep this money. I am not an unsecured creditor. I should get this money back. And the Court of Appeal case in Kimunda said, yes, this is the position. Employer, you need to return, although you have been wound up, you need to return these monies to the contractor, which was the position for a very, very long time. However, in the recent case of Legenda Unggul, the federal court has changed this position. The federal court has said that no, retention monies are no longer trust monies. This means that if the employer has been wound up, the contractor would go in as the unsecured creditor. That means he'll be last in the list. So the contractors were telling it's unfair towards us because the employer were holding this money on our behalf. How can we now go in as an unsecured creditor? So this is what the federal court said. The federal court said, no, I cannot simply create a trust in a contract. For you to create a trust in a contract, firstly, this is very, very important. The contractor must ensure there's express term when they're signing an agreement with the employer to say these retention monies are held on trust. And secondly, they must ensure that the employer place this money into a separate account, into a separate account. If these two things or requirement are complied with, then yes, the monies are held on trust. So contractors here, although we are looking into the employer, but it's also important to note that the contractors, whichever participant who are the contractors here, please remember that, and please ensure that there's an express clause to say that the retention monies are trust monies, and these monies must be placed into a separate account. I know we are rushing, we are running out of time. So perhaps we will just go to the last slide, which is the performance bond. A performance bond is basically monies that would be given by the contractor to the employer to ensure that it fulfills the contractual obligation of the contract. If it fails or defaults in carrying out the works, the employee is entitled to call on this bond, wherein it will be able to utilize these monies for all losses that it has suffered. So this performance bond is not tied to defective works or anything. It is more into of the breach of contractual obligation, where the contractor don't want to carry out his work. The contractor suspends work or so forth. This is when the performance bond would be called. So I would expedite it because, and I think we are out of time. So I would perhaps stop here and just take any Q&A.
谢谢，我们谢谢 Miss Satshani。现在若大家有任何疑问，可以把问题输入在聊天室，我们的 Miss Satshani将会为你解答。OK， 我们的第一个问题是 The first question is.
I read the question already.
Okay, sure.
Okay, can I answer it in Chinese? Can I answer it in English, or must it be in Chinese?
I think you may answer it in English, and then Miss Felicia may translate it to Mandarin. So both, okay? Thank you.
Okay. The first is regarding the procedure to impose LAD. Is it a standard format for CNC certificate to be issued? is there, I assume, is there any standard format for a CNC to be issued? Okay, firstly, there is no standard format for a CNC certificate to be issued unless your contract provides a certificate to do so. So as what I've said, there is no standard form, but what is mandatory in the CNC's notice is to say you're imposing CNC pursuant to whatever clause is in the contract, and how much you would be imposed and how much you would be imposing the quantum of the LAD. So this is what, okay, and what information must be mentioned in the certificate. Two things. You must say a CNC is issued because you have not completed the works within the original contract. Like our case, it was 1st of January, you did not complete the works. So I'm issuing a CNC example according to clause 10 of the contract, and according to clause 12 of the contract, I'm entitled to impose LAD. Then you put, then you explain what is clause 12, which says about LAD, and then you say, then you also notify the employer that you would be imposing this sum. So it's very straightforward. It's just according to the contract, just to say specifying the exact clause in your contract.
你好，我们回答你刚刚 Miss Satshani 回答的问题，有关第一个standard format for CNC，Miss Satshani 回答说，其实没有一个特定的款式 for CNC， 可是确保有两三个重要的要点，就是说第一个，我们要在我们的 CNC 里面说明哪一个条款，合同里面的条款。第二就是说，为什么我们issue CNC， 是因为承包商无法在合同规定的时间里完成它的工程，还有就是 LAD 的数目，就是这三个要在CNC 里面说明。
Okay, thank you. Is there any other questions?
请问各位还有什么问题吗？我们大概会再等多1-2分钟，如果没有任何疑问的话，我们会结束这段线上检讨会。So Ms. Satshani, we'll wait for another 1 to 2 minutes. If there is no more questions, then we may end this session.
Okay, sure, no problem.
Thank you. Okay, Ms. Satshani, we have now received a questions regarding to defect liabilities period.
Yeah, defect liability period, it's not a question, it's actually just a statement mentioned. Unless they want to know how long is a defect liability period, generally a defect liability period is stipulated in the contract. It's usually 2 years, but there is no question stated there actually. So if perhaps they can type out the question.
So Mr. S.Y. Lam, would you like to expand your questions or? Okay, we may wait for a while, okay?
Sure, no problem. Okay, sure. Thank you for the question, Sue Lee Kyong. Okay, in respect of the setup procedure, of course, there are in certain circumstances where the contractor refuses to join you for the joint measurement, which is very, very normal. So what you just need to do first, have a written notice that you have given them. A written notice to say that you would like to have this joint measurement in so and so date. Give them 2 or 3 dates for them to reply, for them to come to on site. If they still don't reply your letter and they refuse to come to any of the joint measurement, you just carry out a joint measurement with, try to get a third party or an independent party to carry out this joint measurement sheet with you. Once you carry out this joint measurement, make sure you send them a copy to say, due to your failure to attend the joint measurement on site, I've carried out this joint measurement with an independent third party, and this is the value of the works carried out on site. So that would be very good.
有关共同测量的问题，刚刚Miss Satshani说，如果承包商不同意进行共同测量，我们可以事先准备一个书面通知，通知承包商说你会在什么时候和什么地点进行共同测量，给他们大概2天到3天的时间回复。如果他们没有回复，或者说他们回复说他们不要进行共同测量，我们可以承包商可以聘请第三方承包商去进行这个测量。过后，我们可以发送这个测量的报告给该承包商，通知他测量的结果。
Okay, the next question, if I can just scroll to the question, as mentioned, CNC must be issued. Okay, thank you for the question, Mohammed. Okay, generally when a claim by the purchaser, which I also one of the purchasers claiming LAD here, what I do is if the developer has not completed the works within the contractual duration, I would usually notify the developer and say that, okay, you have not given me this property by 1st of January. And according to clause example, because you're not legal, so you just say according to clause 1 of the contract, I'm entitled to receive 10,000 as a lump sum for 1 year, example. Because an LAD clause in a sale and purchase agreement is slightly different. They don't go per day. Some sales and purchase go per day. Like my sale and purchase agreement, it was going per year. So I was entitled, example, to 50,000 per year in the in default of the developer. If that was your question. I don't think Mohammed Azman. Does that answer your question, Mohammed Azman? Yes, okay, thank you.
Okay, Ms. Satshani, we have got a question in the Q&A chat box. Okay, Mr. S.Y. Lam, he would like to know more about the limitation period. Okay, specifically in the Limitation Act 1953. Okay, Section 6A of the Limitation Amendment Act and 2018. You may refer to the Q&A chat box.
I am so sorry, Mr. S.Y. Lam. I'm not having the Limitation Act with me here, so I'm unable to actually explain more in regards to this limitation. But if you can just ask me a question, I can perhaps answer that. I can perhaps answer it when I have the Limitation Act before me, and then send it over to Pinyi to send it to you. Would that be good? Hello. Okay, the question was limitation. Sorry.
Sorry, yeah. Okay.
Yeah.
If let's say this one is the Limitation Act, is it can be applied after the what we call this? Let's say the extension of the defect liability period.
No, usually you're bound by your defect liability period.
Yes, I mean if this is a latent defect, okay, latent defect, so that is beyond the what we call this after the this what we so called the.
Correct.
Yeah. Can we apply?
Then it would apply, correct. If it's a latent defect, correct.
It
would apply. It will go beyond your defect liability period. That's correct. Sorry, it will go before. Correct. It will go beyond your defect liability period.
All right. So the next step is what's the limitation period? Up to this 15 years or what?
It would apply up to the limitation period. your latent defect.
All right, all right. So I
It's
would like
tied up to the, correct. It's tied up to your limitation act.
okay, that means that if let's say the limitation period is 2 years, okay, after 2 years, then we discover the latent defects, then we can claim against this one?
You can, because the Limitation Act does not require 2 years. If I'm not mistaken, it's more than 2 years.
Yep.
Yeah.
Okay. Anyway, thank you. Yep.
Okay. If we employ a third party during DLP, we need to find three. Oh, sorry, I'm reading the. Okay, this is to answer Yap Yi Jian's question. Of course, you come to quotation and so forth when it is a huge sum. Yes, I do. We do encourage you to get quotation and so forth. However, if it's something urgent and something that you need to do it ASAP, please carry on, but please provide notice to the defaulting contractor. That's all I think it's important, to provide notice, and then you can get quotation from third party and provide it. But you don't need to go all out to get 3-4 quotations. No, you can just carry out the works ASAP and then notify them. The crucial point is to notify the defaulting contractor. Have I answered your question, Yap Yi Jian?
Further to the hello. Yes, further to the this one limitation X. Is there any procedure to this? If let's say
procedure in respect of the limitation, is it limitation act?
Yes.
There's no procedure per se. No, you don't have a procedure. You can just file a claim in court. You don't have a procedure for it.
Oh, okay.
It's not in like in a construction contract. There's no procedure.
All right. So it's not like the defect liability. That means that we need to write in to the contractor.
No.
All right. Thank you.
You're welcome.
Thank you, Ms. Satshani, for answering all the questions. And I believe that that's all we have, all the questions we have right now. So I'll continue it and end this session. Thank you.
Okay, thank you so much for your time. Thank you.
谢谢大家的参与。如果大家已经没有任何疑问，我们将会结束这个研讨会。So before 我们结束这个研讨会，请大家扫描我们荧幕上的二维码，对我们今天的会议做出一些反馈。Can someone provide a QR code, please? Okay, 谢谢大家的参与，我们今天的研讨会到此结束，谢谢。That's all for today. Thank you, everyone.